Yes, Mr. Payne.
My lord. Can I introduce the parties first? I appear on behalf of the appellant, that's the London Borough of Islington. I have with me my instructing solicitor, Miss Hamlet, and Miss Khan, the allocated social worker.
Yes.
So to my right, Miss Mia represents the first respondent mother. The mother herself is not well today and so not in attendance.
Right.
Also attending is her instructing solicitor, Miss Dynam.
Yes.
To her right is Miss Sultan, who represents the father.
Good morning, my
He himself not attending today. Miss Sultan has a mini pupil, Miss Foster, with her as well. Then Miss Ferris attends to represent the children through the children's guardian, Miss Smith, who's also in attendance, alongside her instructing solicitor, Miss Little.
Thank you.
My lord, can I extend gratitude of all the parties? The Court obviously the Court of Appeal has worked extremely hard to ensure access to recordings relating centrally to the appeal points, and the provision of a transcript overnight has assisted the parties hugely.
Well, a lot of the credit for that goes to our judicial assistant,
Yes.
Ms. Coley, who's been instrumental in achieving that. I'd like to say in return that I'm sorry that it wasn't possible to arrange the listing so that, in a sense, trial advocates could appear. Can you remind me, do we have any of the trial advocates?
One, and that's Miss Sultan.
Miss Sultan,
Good
good.
morning, my lord.
We also, sorry,
That's going to be very useful. So Miss Sultan will be a witness in relation to all actual matters. And Miss Little is also present, and other people are here who were actually present. But I'm afraid as soon as we thought about moving the date, all sorts of other things fell away. Similarly, although it's placed a lot of pressure on you all as advocates to deal with matters within hours of the hearing, if we'd felt that another week would have meant that everything would have been easy, then no doubt that would have been a good reason, but probably it wouldn't have led to anything being much better. So I'm glad if everybody feels that they're all here and ready to deal with the issues which arise on the appeal.
we are. So thank you very much, because the provision obviously of the recording, of course it's a recording linked to the 7th of October.
Yes.
I understand technical difficulties relating to the recording of the 6th of October means I don't think it's even accessible to listen to.
Well, I think we will all have, those of us who weren't obviously present, will all have formed a picture of the sequence of events that took place, and we'll welcome your help as to whether the picture that we've formed is correct or not. But together we'll piece together what has happened. And for the moment, I don't hear anybody saying we can't decide the appeal because we don't have the recording of what took place on the 6th, because the 7th was in a sense so hard on the heels of that I think we're probably able to fill in any of the gaps that result.
My lord, I can be clear on behalf of the local authority. We feel extremely able to be able to present the appeal today. The absence of the recording of the 6th of October, we submit. In fact, once the recording of the 7th of October is listened to, but the transcription read, arguably that goes further, the judge's own words, he goes further from what he had said on the 6th of October, and it was clearly a continuum we would submit from the indication that he made on the 6th of October, and then what subsequent we say he decided on the 7th of October. My lord, can I also extend a gratitude, of course, in relation to the identification of some additional case law that hadn't formed any either key or central part of the submissions on paper. I think we've all been able to access those references as well, and we'll assist where we can through the course.
Could I just say, as I should have said at the beginning, that as this is a case that involves children, no report of the proceedings is to identify them or their family members. I don't think it's really going to be necessary to use names,
no.
And if counsel could use initials where
Yes.
possible, particularly if you read something, which I hope you won't have to. Be careful about reading out names.
And my lord, I will do my level best as well.
Yes.
Can I, if I may, of course, in terms of courtesy, there's an appeal bundle that includes all the written submission documents. And my Lord, I think subsequent to the appeal by the local authority through the Guardian's response, additional grounds were then identified, and your Lordship made an order yesterday that then confirmed effectively that was listed before.
Well, one of the decisions we have to take is whether to grant permission to appeal to the Guardian.
Yes.
I would suggest that we don't deal with that as a preliminary matter, but that we hear from Ms. Ferris in due course.
Precisely.
And if she can get any of her grounds on their feet,
Yes.
permission may follow, but other parties will have the opportunity to respond to any arguments that she makes. But
My Lord, yes.
we leave it to you to deal with the ones the arguments that you wish to make
Yes.
on your own grounds.
Well, my Lord, can I perhaps start with the transcript, effectively the recording that we have of the exchanges on the 7th of October. In my submission, that on the face of it, plainly and obviously identifies ways in which we submit His Honour fell into error. The principle, if I perhaps acknowledge this, my Lord, the principle of a dynamic set of proceedings, and of course the ability of a judge to, at any point within that process, as part of the wider case management, an oversight of a particular application, has the ability to identify either gaps in the evidence, weaknesses in an individual party's case, and ways in which, as a judge, they are likely to be assisted or not by certain evidence. The difficulty, and we submit, ultimately the fatal decision by this judge, was clearly on the 6th of October. He signposted very clearly that he was not going to be able to approve the local authority care plan, which of course is one of adoption. Now, obviously, my Lord, I'm not going to be able to get into any detail of the exchanges on that occasion, but as I've already effectively acknowledged in opening submissions, when we read the transcript of the 7th of October, we can start, in fact, with His Honour introducing, right at the outset, an acknowledgement to the parties that given what he had said the evening or the day before, the dropping of a bombshell, that asking openly to the parties could they carry on as if nothing has happened. There are then, my Lord, exchanges with local authority advocate Mr. Coates that fundamentally, we submit, confirm that he in effect makes a decision that he is not going to be able to approve the local authority care plan, that he's not going to be in a position to ultimately make a placement order, and he effectively makes what we would say a clear decision on a key part of effectively the proceedings. If I perhaps just acknowledge this, effectively at that stage of the proceedings, part heard in the oral evidence, evidence being heard within that phase from the allocated social worker and the mother, and then due to hear from the family finder and the guardian. Critically, what the local authorities say is that the balance of the evidence clearly was going to go to a welfare analysis that the judge was yet to carry out. We submit that in fact what His Honour did was in effect carry out a linear process and determining a key part of the presented plan, and by very firmly saying that he was not going to be in a position to make a placement order, and he could not effectively approve a plan of adoption, that he was making a premature, inappropriate determination My Lords, if you follow that through, given the application that was before the court, it was going to require a global holistic analysis. Within that, the identification of realistic options for permanency in relation to the subject child. Clearly, a plan of adoption, we submit, was a realistic option. It might be right, of course, that having heard all the evidence, submissions, and then carrying out that careful welfare analysis, that the judge would have reached a decision not to approve that plan. But to do so, in effect, partway through the final hearing in the way that he did, we submit that he clearly fell into error. And my Lords, we say, actually, when reading the transcript, there are several points within that transcript where it is plain and obvious that, in effect, His Honour made that effective.
Well, would you take us to those in a moment? Just to check my understanding, the judge had there was, I think, a 5-day hearing in February listed, and that stopped on day 2. For further thought to be given to the older child's arrangements. The judge then made, I think, 2 orders during the course of the summer after hearings, which were principally to do with the older child, and no doubt there were other directions given as well. But when it came for this 3-day further hearing, there were live issues in relation to both children.
My Lord, yes.
In particular, their mother retained a wish to resume their care.
Yes.
The impression one gets maybe more strongly in relation to the younger child than the older child, but still her formal position was a claim to both.
Yes.
And so those sequence of 4 hearings represent, do they, the totality of the judge's involvement. The case had been going on for so long, and we have, quite rightly, only a little tip of the iceberg.
Exactly.
But it looks as if we're getting the message that the judge's involvement is as I've described.
It is, my Lord.
Right. So I think there was a deputy district judge who made the order in relation to the, I call them the middle children.
Yes.
In December of the previous year.
Yes, that's right.
Right. Okay. So on any view, the judge had been closely involved with the case throughout 2025.
My Lord, he had, so certainly to a sufficient extent of understanding what the issues were. Clearly the evidential canvas that included obviously transcribed evidence from some of the previous hearings as well.
We haven't also got, and I don't complain about this, the documentation, still less transcripts of the 2 witnesses who gave evidence in February. Were they principally focused on return to mother, or were they offering broad views of all the options that faced each of the children?
So, my Lord, we have, certainly within the appeal bundle, we have the transcript of the Dr. Corr's evidence. That was going back to September of 2024 and indeed February of 2025.
Yes.
There was then transcribed.
And she's a psychologist.
Yes.
And was this a psychologist directed towards the children or directed towards the mother?
I think it was the children and family, but
children and family.
Yes.
Right.
But in relation to the independent social worker, Ms. Stollard, that I think transcript remained, I think, outstanding.
Right. And the independent social worker was concerned with what task?
So obviously providing a report in relation to the mother. I think certainly when it came to the hearing...
Is that a parenting assessment of the mother?
Effectively parenting capacity.
Parenting capacity.
I know when it came to the hearing in October, obviously a 3-day hearing relying in part on previous evidence that had been given, but and whether this, my lord, is where you're perhaps focusing in on particularly the realistic options, arguably, that were before the court. Certainly the options for placement with either one or other of the children, possibly both, with their mother. Arguments about long-term foster care, with one obviously in residential placement, and of course then a care plan still in relation to the other, and of course the focus child of this appeal, of adoption. Now within that, those effectively, obviously the father remained and is a party, but he was not in a position to effectively advance a primary care role, as far as I understand, for himself. So within that context, those were the principal areas of focus in terms of permanency plan. What we submit happened through the process of, partway through obviously the oral evidence, but on the 6th and then the 7th of October, His Honour very clearly and very firmly effectively ruling out one of those options. Now, the circumstances in which a judge can do that, we say this was not the set of circumstances.
Well, you could have, I mean, to use some jargon for a moment, a North Yorkshire decision,
yes.
Which is where in a care case it's apparent that one option is not realistic. The court can, after due consideration, say so.
Yes.
But that's a formal process that would have to be argued and reasoned in the normal way.
Yes.
But it's quite often possible to say, for example, that a particular parent is not going to be further considered.
No.
So I suppose you could theoretically, although I'm not sure we've seen it happen,
No.
have a sort of North Yorkshire process where adoption could be taken off the table by the court after due consideration. But the words after due consideration, obviously.
No, my lord, I accept, particularly in the context of public law outline, making hearings work, and of course the IRH process, there will be sets of circumstances in which, when that process works, then what appears to be a range of issues in terms of permanency may be narrowed down within that process.
But in particular, adoption, as it did for the older child, might come off the table as a result of some sort of dialogue between the court and the authority.
Exactly.
Where it said, we'll accept the steer from the court, but
Exactly.
That wasn't what was happening here.
That wasn't, and I think just to perhaps emphasise with that, what we say is that demonstrates a set of circumstances in which the local authority responsibly acted upon the evidential canvas, obviously the particular needs of that child. But when we get to the hearing in October, it was a wholly different set of circumstances. And in fact, if we take through some of the difficulties, once the judge made clear, in effect, that he was not going to be able to make or approve the care plan of adoption, but effectively make the placement order, then that created, both for the local authority, separately for the guardian, and Ms Ferris will address this, a situation where it was faced with attempting to explore with the judge the benefit of hearing the balance of the evidence. And so, if I just perhaps make this
Yes,
suggestion.
I think I interrupted you when you were going to the, we call it the transcript. We all know that it's not a transcript, it's the best
Exactly.
we can do in the circumstances. And if any if anybody who's been listening to this has any corrections to suggest during the course of argument, please feel free to do so. It's not definitive. Right, did you want to take us in a sense to the points in the transcript which you say represent a determination?
Yes, so if I start, I have the transcript available with me here. I've mentioned, obviously, it is relevant that His Honour introduced right at the outset the wording that he does.
Yes.
We then have the exchange where the local authority obviously seeks to effectively clarify what that means. That then first main exchange, my lord, where the judge says, no, Mr. Coates, I don't mind not beating about the bush. No, it's not a preliminary determination. It is a clear indication. I think the clear is underlined because on the recording there is emphasis in that. Clear indication, I cannot at the moment accept the care plan. It goes into that, making reference, predicting what he will hear from the family finder. Can I just pause with that? Family finding evidence, of course, primarily will deal with timescales. Family finding evidence can also deal with the impact on a contact order being made, what that would mean in terms of searching for adopters, but also perhaps highlighting the commitment now we see from local authorities acting as adoption agencies to promote contact within adoptive placements.
Can we just put ourselves in the courtroom, as it were?
Yes.
The impression that may be created is that while all of this was going on, the family finder was sitting waiting to give her evidence.
Certainly at a point, because she was on the link, you'd have heard the recording.
And I think I gleaned that the mother was herself joining by link rather than in person. So are you able, or others tell us, did this start at, say, 10:30 in the normal way, and then...
So timing, I'll have to defer as much as I can, my lord.
But I think we'd like to just understand so that we can fairly assess the situation. You know, if it, for example, started at 10:30, it went on for a certain period of time, there was then a break,
yes.
And then a resumption, and then it ended. And in the meantime, as I've understood it, the family finder was sitting there waiting to give her evidence. And the guardian, at least on the previous evening, had been expecting to be in the witness box that morning as well.
Yes, that's right.
Well, let's try and piece that together as we go along.
Yes.
But don't stop.
No, my lord. I won't, because I know we've all had time to sort of read and digest. But if that first exchange, his Honour, at the end of that, I can't think of any evidence that I'm going to hear that will change my mind.
Is that from the Guardian? I think it says in the latest.
Yes.
emanation.
Yes. Sorry. Yes. Then the further exchange that leads to this, and I'm looking then at the second page of the transcribed document. This was the exchange in terms of a ruling, but I stand by what I've said. I'm entirely satisfied that at the moment the evidence I've heard relating to evidence that is about to come, I do not see that there is any evidence that I could hear, that will change the view I have, which is that adoption, it may appear to be the only realistic option, feasible option for the long term. He then, I won't read all of that, but then goes into what appear to be a complete focus on the negative, predictable negative, and some we would submit far into the future, and potentially appears placing far too much weight on future risks without any sense that there's a balance, even within that exchange, of the positives to the subject child.
We're not concerned with there are a number of grounds of appeal,
yes,
which I appreciate you didn't draft, but there are a number of grounds of appeal which rather concern a situation that might have arisen had the judge refused the application for a placement order, but he didn't do that.
No, exactly.
And so we understand what you're saying, but I'm not quite sure how it becomes a ground of, as it were, a separate ground of appeal. It simply illustrates your main point about predetermination, as you put it.
It does, my lord, and in fact, that is the effective gravamen, but that's the central tenet of what we are arguing. That he draws himself into a determination and makes a decision. That decision, when one reads later into the transcript where there's the exchange that he's in effect reassuring that he's not, it doesn't mean that he's returning the children, but back to the mother. But it's clear that he, in the one sense, of course, he hasn't made a final determination, but by effectively ruling out one key element of that welfare evaluation, it's clearly, we say, an error. And again, it's really perhaps by emphasis. When, obviously, the welfare analysis that is central to the decision-making, in particular, obviously, in relation to the application that was before him, it required him not only to hear the relevant evidence, and even if it's arguable that the family finding evidence perhaps was not going to assist him that significantly, although I argue there is evidence that's likely to have assisted him from that witness, the guardian's evidence, to say that nothing that she was going to say was going to help him in any way, shape,
but if we take the family find for a moment, I don't want to put words in your mouth, but it might be the case that if it had simply been that the judge had heard the guardian and said, look, I really don't need to hear the family finder, that we wouldn't be here today.
That's almost certainly right. Absolutely. And then
I appreciate why you refer to the family finder, yes. But the real nub of this is in relation to no guardian and no submissions.
No, and the fatal flaw that has is that obviously the guardian was supportive of the local authority case, but she's independent. She's the voice of that relevant subject child. So the denial of that key part of the evidence is crucial. And obviously we can read the difficulties the judge himself was having. He could have, there are a number of ways he could have articulated the difficulty he was having with the local authority plan, perhaps gaps in the plan, particularly in relation to contact and the degree of the continuing relationship that he was drawn upon in terms of the Adoption and Children Act welfare checklist. But signposting and giving all the parties an opportunity to understand where his thinking is very different to where he reached. He reached a very clear, firm, determined position. And my lord, of course, the fact that 3 of the advocates before your lordships today were not there, there's this objective ability for all of us to read what is said, the exchanges that take place. And what we ultimately say is one only has to read what the judge said, understand the implications that flowed from what the judge said, and then begin to understand why it effectively called a halt to that hearing in the way that it did.
So you've taken us to the parts of the transcript on which you particularly rely. Yes. It's all there to be read. But the sequence seems from the transcript as a whole to be this, that the judge gave an indication on the first afternoon, then gave it in what he described as being more trenchant terms.
Yes.
You would characterise that as effectively a decision. Gave the parties time to consider what happens next. And then during that break, Mr. Coote sent in a document expressing the local authorities' difficulties
Yes.
with this situation. And no sooner than the parties come back into court, the judge grants permission to appeal without hearing from anybody, and the proceedings thereupon become stayed.
Yes. Now, my lord, I'm being careful not to be drawn into trying to obviously read the judge's mind, but perhaps from the way, particularly when you listen, but the way in which he has overseen that through the 6th and 7th, giving the permission, it is arguable to say that he knew the import of what he was saying. Of course, in terms of the respondents, the parental response to the appeal, a lot is placed on an indication. But fundamentally, when we read and understand what the judge was saying, he's quite clearly, we submit, ruled out adoption as a realistic option for the child. And by doing so, that's essentially where
So the situation was reached where either during the break-in proceedings on the second day or in the light of the judge's order, the local authority and the guardian had to abandon their case as to what was in the child's best interests, or come here.
My lord, so let me perhaps deal with it in this way. Yes, in terms of abandon, and of course there was the exchange that the judge had with Miss Little as the guardian changed her position, and that was no. In fact, there was a detailed position statement that had been signed effectively to then stand as evidence that was underpinning some of perhaps the gaps that had been identified in the previous evidential witnesses. Obviously, the option of then seeking permission to appeal come here. Of course, I'm conscious that an issue has been raised about recusal, and of course, the option that could have been available was available effectively.
Well, could we look at the document that that Mr. Coots sent in to the judge?
So, my lord,
Is it on B1, page 61 of
yes, I've got that.
the electronic bundle?
Yes, thank you. We have the exchange. I think Mr. Coots confirms with the judge he had sent an email. I understand
Yes.
this then forms the content of the email.
Yes, so it says everything except what it was probably the label for what was going on here, which was a recusal.
Yes.
I appreciate it's much easier with the benefit of distance to make other suggestions, but I mean, is this in effect, as a permission to appeal application? It could have been expressed differently, namely that these are several reasons why you couldn't continue to hear this.
Certainly, I have to accept that has to be right. Now, obviously, what we know is that there wasn't a recusal application. Can I perhaps make this submission that in the exchanges that there are with the judge, he makes plain, particularly when having granted permission to appeal, he doesn't think he's done anything wrong. The permission he links to making sure that there isn't any further or minimising any delay. But really, throughout the exchanges, he absolutely believes that he has done the right thing. And so if one layers over that recusal application, it's difficult to see in what circumstances he would have permitted or effectively agreed with that application at the time. So I acknowledge that there were other avenues that could have been pursued.
But if is your essential point that if it had been framed as a recusal application, it's you say it's likely the judge would have refused it.
I do, my lord.
One can't know, but in any event, it doesn't really make any difference by the time it reaches this point, because what's happened hasn't either advantaged or disadvantaged any of the parties.
That's right. So we have that procedural element, but fundamentally, we obviously we can't unsay what is said, and so that is out in the open. And the judge has gone to such a point beyond we submit what is effectively permissible in those circumstances. He has gone way beyond a point that then leaves certainly the local authority, but perhaps certainly two of the parties in a position where they feel that they can complete a fair hearing before that tribunal, given how very clear he was in respect of one key element of the care plan. Now that, my lord, is essentially the appeal at its core. I'm not sure what more will be said by me that will assist, but of course, where I can, I will.
No, for the moment. Thank you very much, Mr. Bain.
My lord,
I wonder, would it be leave the choice to you, Miss Mir, Miss Sultan. It seems to me probably fairest that we might hear from the Guardian next, as she has an application to make, rather in the same way as the local authority is putting it, so that you're then able to hear everything before you you present your case.
Yes, my lords, that seems very sensible.
That's helpful.
Thank you.
Great.
Okay. Let's do that then.
Yes, thank you very much. The skeleton with the additional grounds, I'm grateful that all parties have received that, and that your lordships gave permission for that to be considered. My lord, I rely on behalf of the subject children on the submissions that you've already heard on behalf of the local authority. And in providing the additional grounds, it was the Guardian's very clear view that there was a need to bring things back to basics, and her very clear view that at the point at which the trial judge had made a decision, it is impossible to read that transcript without forming the view that this was not an observation, this was not an indication, this was a decision. The court's mind had closed. It was no longer within the remit of, obviously, the case law has reference to open minds and closed minds. And anybody reading this transcript would leave knowing that this mind was closed. There was absolutely no possibility that this was a judge that was going to consider as a realistic option and make a decision on adoption being in the interest of the subject child. And
well, I don't want to split hairs, but we can't know whether the judge considered adoption as a realistic option. You could say that he didn't consider it was a realistic option, or he considered it was a realistic option that should be rejected. No, should I say that again?
yes, please.
Right. Well, you said there's no possibility that the judge would consider adoption as being a realistic option. In being a realistic option doesn't mean it's the best option or a necessary option. It's just something that could work and needs consideration.
Yes.
Right. So it's equally possible to what you said that the judge thought, well, it's a realistic option. Indeed, he mentions realistic, feasible option at one point, but it's not one that he could ever bring himself to approve. And that's an alternative way of probably getting to the same point, but you'll see why I was speaking about splitting hairs.
And I apologise that is certainly the Guardian's view was that there were three realistic options, and that the judge's decision, we say, had in essence focused on effectively ruling one of those out, and the grounds of appeal that I'd included within the skeleton argument deal with the issues that pertain to such a decision. And those really, as my learned friend Mr. Bain has said, there are issues with linear analysis. There are clear issues with a minimal consideration of the welfare checklist. I think I should amend the ground that suggests there was very limited. Having seen the transcript and heard it, I could see that there was more, and I apologise.
No.
But I hadn't had the benefit of that.
But
so clearly
the main point that struck me from your argument, whether it's right or wrong, is that, I mean, the only order that the judge actually made of any substance was to stay the proceedings.
Yes.
And that's really what the Guardian is complaining about.
Yes.
If ever there were proceedings, she would no doubt say, that shouldn't be stayed, they were these. 2.5 years for a 1-year-old. So that's really the only order that the judge made, and that's the subject of your additional first ground, isn't it?
Lord, yes. Yes. My Lord will have noted the phrase unconscionable, and I think that's probably something that everybody at this front bench would share. I think it's uncontroversial.
Can we, because we do have to deal with this formally, can we just look at your grounds to see whether you you particularly want to elaborate? Ground F is set out at page 33.
Lord, yes. The
ground G is that you've got to say why you don't agree with the Guardian.
yes, yes. My Lord, I hope that it's uncontroversial, but
yes,
clearly the judges.
Right. Ground H is the
yes,
linear analysis point.
already been dealt with. I think that's probably OTOs, and obviously I, and I think it was here that I have been.
Yes, there was a passage where the judge ran through
yes.
the welfare checklist
primarily
with some
the Adoption
comment.
and Children Act. But yes, wishes and feelings. But my Lord, I think as a broad brush point, it has relevance. But I would have amended these grounds.
Now, could you help me with this? Was the Guardian appointed in relation to all 4 children at the beginning of these proceedings? Right, so the Guardian's appointment went back to I'm sorry, was the youngest child added to the proceedings?
June 2023.
June 2023. When the proceedings were brought in relation to all of the children?
Yes.
That's
yes.
right. Did the Guardian give evidence in relation to the, as I'm calling the middle 2 children, at the hearing in December?
The answer is no, she did
Right.
not.
Well, not to be flippant about this, but did the Guardian ever get into the witness box in the course of 2.5 years? And so, I mean, obviously this judge's involvement only began in February, but it wasn't a situation, as it were, where the judge might say, well, the Guardian and I are old friends. I've heard from her often in relation to aspects of this case, so I gathered her view of this.
No, it was not that. Lord, may I just perhaps address you for a moment just on the issue of recusal? On the issue of recusal.
Yes, how do you analyse this?
Yes, well, the Guardian and, of course, the children's solicitor was it's tried, but was very keen to conclude this hearing, and had taken from the observations on the 6th that they were to be reflected on and they were to be considered. But
so, again, I don't want. The impression that we've got is that the Guardian heard what the judge said, whatever exactly it was on the 6th, but did not conclude from that the judge had made a decision.
Hadn't tipped into.
Right, so it's accepted by the Guardian that whatever the judge said on the 6th was an acceptable indication.
Yes, it may have been a slight overstep, but not within the parameters that we found ourselves on the 7th. They were certainly matters on which the children's team reflected.
So I'm just trying to make a note. It's a strong indication.
A strong indication, but one which was properly reflected on and considered for the purposes of the following morning. And there was every hope that, my words, that the judge would row back, perhaps, from a position that had been adopted. But again, my words, the judge doubled down on what had been a reflection the day before. And really, to such an extent that despite this very experienced Guardian's view that everything should be done to conclude, really found themselves in the position that is clearly recorded within the documentation. But perhaps by that point it had gone past the opportunity for a recusal, which may have been a consideration on the 6th.
Not quite understanding why it was too late for recusal. I understand that the Guardian was particularly concerned about the thought of no decision being made, because presumably, was this a Monday, Tuesday, Wednesday, or?
Let me check. Yes, it was. Yes.
Right. So presumably the Guardian came to court on the Monday, thinking that finally and at last decisions will be made for these two children on Wednesday.
Yes. Yes, exactly.
And even on Tuesday morning, again, I don't want to make assumptions, so correct me. The Guardian was expecting to be in the witness box, probably on the middle of Tuesday morning.
Absolutely.
Right. Instead of which, a certain amount of time, which, if you can help me about what it was spent on what we see on the transcript. Yes. So, can you help through Miss Little as best possible as to what actually happened that morning?
I will. Yes. The parties would have been at court before 10, but it's understood that they would have gone in around 10:30. We have the exchange, and by 12:40, these exchanges had taken place, and it was at 12:40 that the judge took the decision, or that the judge granted permission to appeal. Yes.
Right, so we can probably put it together, because I'm trying to remember the first sequence is 20-something minutes.
Yes. And then there was time outside court.
Right, so by 11 o'clock everybody's back outside.
Yes. Yes. Yes.
And then you come back in sometime after 12:30?
Yes, 12:40 is the time that the Guardian's heard.
Right, so 12:40 back in. In the meantime, the document created by Mr. Coates had been sent to the judge, and then by 1 o'clock you're out.
Yes.
12:50, it was 10 minutes.
Sorry, 12:50.
12.
With no evidence having been heard.
No.
And the proceedings having been stayed. Okay.
Yes. My Lord, unless I can assist further.
I mean, just one point. To some extent, naturally, emphasis has been on what the judge said about not seeing circumstances in which he would be assisted by the evidence, including of the guardian. Is it also part of your argument, just so that the parents' representatives can think about this, that he hadn't heard any submissions at that point either? And it's arguably not just about evidence, it's about submissions. But on your argument, as I understand it, you say that he had said, I am not going to make an adoption order. So he did that without the evidence or the submissions. Yes, so is that part of your...
Part of it, perception of fairness, all of these matters that are so intrinsic to arriving at a fair, proportionate and necessary decision in light of having heard all the evidence. Not seeking to reinvent the wheel, but Lord, yes, the concern related not only to the lack of oral evidence, but of submissions from all the parties.
Well, and also, I mean, let us suppose that a number of the things that the judge said in the comments were included in a judgment which was given on the morning of the Wednesday. No doubt involving many other aspects of the matter and balancing them all up and coming to the conclusion that the reasons the judge would have given adoption wasn't right for this child. Might be thought that this is the sort of case where a reasoned judgment of that sort would be open to the court if things had arrived at that point, but just didn't get there.
And certainly the sense is that there was just a lack of fairness and
I think
concern for the guardian.
One thing that I've been considering is that really the only decision for us is essentially which judge to go back to, and if the appeal is allowed, it's one. Appeal or appeals. If the appeal is allowed, it's one, and if it's dismissed, it's the other. I imagine you would say that to return to Judge Oliver with the best will in the world would place the guardian in a completely impossible position.
My lord, that must be right. This was a judge who made comments that he wouldn't be able to sleep at night if adoption were on the table, and to have gone perhaps into that level of detail and then remitting to that judge. Yes, the position on behalf of the guardian would be a very, very difficult one.
I don't think we've any of us got experience of somebody, of calling somebody to give evidence in front of a judge who's already said that they're not going to attend to it.
Yes, nothing that can be said, heard or done would change your mind. That is as trenchant as is possible to be in my submission. Unless I can assist further. Thank you very much.
Good. Thank you very much indeed, Ms. Ferris. Yes, Miss Meir, and thank you to you also for making yourself available. It's been quite short notice.
My lord, I'm grateful. Thank you. Just starting with the points on behalf of the guardian. Of course, I was not the trial advocate, as you are aware. And having read the transcript, which has been helpful, there is an overview. The skeleton argument sets out very clearly on behalf of the mother the concerns with respect to the appeal. And I say that it is right that what the learned judge gave was an indication, not predetermination. And that is despite the comment you made about not being able to sleep at night. In the case law that was circulated this morning for the parties to consider the 4 cases, there is reference to judges giving very strong indications, robust indications, but essentially the question remains, and that seems to be, from the case law that has been circulated, in particular the London Borough of Southwark and the Jimenez case, and then reinstated by Lane's Group, is the question of whether the judge has essentially closed his mind. And in my submission, it's not right that he did. What he did do, and that's reflected in the transcript, I would say, albeit limited transcript, because I believe there were further submissions made on behalf of the mother and the father and the other parties, but he did invite the Guardian to consider whether she did want to give evidence, and if she did, he would hear it. Now, it is right that the Guardian hasn't given evidence in these proceedings, and that includes the final hearing in February for the older 2 children. The reason that
December?
February. December. Oh, sorry, I do apologise. It was December.
Yes, I think there was a short gap between
yes,
the.
Yes, exactly. And that is, I'm assuming, but I think it is right, because the care plans were agreed for the older children. So the need for the Guardian to give evidence when the care plans were agreed, it wasn't required. What the Guardian had prepared was a detailed analysis, which is right, and it was detailed. And the Guardian,
could we, just before I forget about it, you would appreciate that as you pointed out, the note, the informal transcript, is not of every minute of our tapes. And if there is a passage that's not on the note, then please draw it to our attention. I don't mean necessarily now, because there's a limit to what we can do with it. But you're saying that there was a point where the judge invited or asked whether anybody wanted to give evidence.
Well, in the mother skeleton argument, it's set out, as well as on behalf of the father. The judge did give the option to the parties, while the judge gave the indication that he didn't consider that the placement order was right, or he couldn't endorse the local authority's care plan. He did. At what point?
I'm just trying to recall from listening to the proceeding.
Yes, I'm helped. The day before, I believe, the judge had stated.
Oh, sorry. We're not talking about this transcript. We're talking about the first day.
Yes.
Okay,
yes,
I understand.
My lord, sorry, that's my fault not putting it clear enough. But certainly, the judge had not closed his mind to the Guardian or the family finder giving evidence, and had taken an approach that the family finder ultimately, why the judge, again, it's in the skeleton argument, but I can assume that it's on the basis that a family finder would only assist with the amount of time it would take to place a younger child, and so the judge felt that he needn't be assisted by that, and certainly the views of the parents appeared to be that they didn't need the family finder in any event. But really the question is, and it's made very clear on behalf of the mother, that the Guardian did have the option to give evidence, but it wasn't an option she decided to take. The judge didn't close his mind to not hearing any evidence at all, but it is right that during the course of proceedings, when a tribunal hears the evidence, certainly either at the beginning or during or following evidence of the parties, in this case, the judge didn't give this clear indication at the outset. He heard the evidence from the social worker, he heard the evidence from the mother, and following that, he gave the indication where, in his mind, the local authority's care plan for placement orders for the younger child were not in the interest of that child, and ultimately that is an indication that the judge can give without bias or without clear bias.
Now, I am certainly sorry that Miss May's availability was not able to be responded to, but could you just take us to the part of her skeleton argument which you're particularly referring to?
Yes.
In regard to the possibility of the guardian giving evidence?
Sorry, my lord, it's page 6 of her
Thank you.
skeleton argument. It's
55 in the electronic 52. Paragraph?
paragraph 29.
Thank you.
And I do apologise. My submission is based on the judge making it clear that parties were entitled to give further evidence.
Where does that come from?
Following his indication, he gave, just paragraph 29, he gave his indication on the assumption that the children's guardian would not change her position, which he was entitled to do, and it was correct, as she supported the local authority appeal. He had her detailed analysis and was prepared to hear her evidence in any event.
So what that you say comes from something that was said on the
yes,
on the Monday?
I expect it does, because the judge didn't close his mind to not hearing her.
Yes, but the difficulty, if I may put it to you, is that the judge seemed to think that by the following day it would be a waste of time.
We don't have the full transcript from the following day, which I know, or parts of the transcript, or parts of what was being said in court. And certainly, the guardian was given the opportunity, it seems, to consider whether she wanted to give evidence. And based on the indication, perhaps she chose not to. But the point is that there was an opportunity that he would hear the evidence, but he wanted to make it clear that his view was that the local authority's care plan was not in the interest of the child, having considered the welfare checklist, having considered certainly the contact order, that was the Section 26 order that was agreed. He was entitled to come to that view in my submissions, because it is part of his it is within his remit, and of course it's part of his holistic observation and assessment of the
Would it have been,
welfare.
just to take a thought experiment, let's suppose that the judge had considered, before hearing your client give evidence, that there was no possible way in which he was going to agree to either of the children returning home.
Well, often, and I say this generally, he can give an indication, and if he had stated that he can't, on the evidence so far, be satisfied.
No, if he said that he was not going to approve that, he couldn't conscientiously do so. It's in the same context. Is that an acceptable way of proceeding?
Well, I would say that if he hadn't, if he states that and then follows that with, well, actually, there's no point in hearing the mother's evidence because that is a decision or a predetermination I've made, then potentially yes, but that's not what's happened here.
Okay.
The judge didn't follow that by saying, well, actually, I don't want to hear any further evidence, and that's a decision I've made. And ultimately, it does come down to that. And that is the fine balance, I would say, between an indication and a closed mind. And in my submission, it is correct. And he did act correctly. I know you have been drawn to recusal and the test of that. And of course, we're also you've been addressed on his allowing the appeal. But of course, he allowed that appeal on his own words, on to avoid delay. It may have become clear, given the exchanges between the parties, that an appeal was imminent in any event, following whatever conclusions, how the case concluded. And delay is certainly a concern for all parties in this case. We are in proceedings.
Well, can I say that regardless of the outcome of this, I, and I think my Lord shares this view, feel the greatest possible sympathy for your client in this situation. To be subject to proceedings for 2.5 years in relation to your children without knowing what the outcome is going to be is absolutely excruciating. And so nobody is spared by this sort of procedure.
No. And that must have, and that of course does form his thinking. And certainly when we read the transcript and the exchanges between the parties, it is right that he has to give proper consideration and thoughtful consideration to post-adoption contact, seeing as the parties were agreed on Section 26. The skeleton argument before you on behalf of the mother sets out in particular the case of Rien, which does give the judge right or recourse to consider and place adequate weight on post-adoption contact. And in this case, having given his indication, he was right to place weight on how that would look for the younger child throughout her minority and throughout her life. Of course, we know that an adoption is the most draconian order. We know that nothing else will do. And ultimately, it's not limited to just the current time or a couple of years. It's how it will impact a child throughout their life. And he was right to make those considerations. I would say that there's nothing that I have read in the transcript, in the excerpts, that suggests that he went beyond his scope and made determinations that were beyond his scope. He was right to consider how it would affect her throughout her life. And of course, she is the only child from this sibling group where a potential placement order is being made. And so again, he has to consider that and give that adequate weight and how that would impact this child throughout her life. Again, it's nothing that suggests that he's overstepped, or he's overstepped to such an extent where his mind is closed, rendering the proceedings unfair. And ultimately, that is the question. Whether you send it back to this judge to finish these proceedings, to get them finalised and to give some conclusion to the parents, or whether it goes to a different tribunal. And of course the court has to bear in mind how that would look, when that would be, and I know there is an expedited list, but that is a real concern here. How long that will take, and evidence being reheard. And how that will impact.
You're pushing at an open door in suggesting that that outcome could only be contemplated if it was necessary.
Well, exactly. And I say it's not.
Yeah.
There isn't enough, I would say, that the applicant has set out that could justify such an approach. May I assist further with any of those points?
Sorry, just a moment.
The point that's arising is thinking about what a further hearing in front of a different judge would mean, and the extent to which that judge could rely on evidence already given, the extent to which new evidence would be required, the extent to which updating evidence would be required, etc. These are probably, if that eventuality arose, matters for some proper case management and trying to focus on what the real issues are.
Oh yes.
But it would, clearly a more onerous process than it would be if the judge could complete the hearing himself.
My lord, exactly. And you had said, and it was agreed from the outset of these proceedings, I believe it's the first, so this hearing is the first point that my lord had made and inquired about, is this judge's involvement in these proceedings, and he is very well informed, he's experienced, but ultimately he has knowledge of the case, substantial knowledge of the case. The issue, of course, about different tribunal is delay, but also it has to be how that evidence is induced, what impact or how much what transcripts might be available to the judge. But it is going to be inevitable that it is going to cause not just delay, but certainly for the parents, it will ultimately, certainly on behalf of my client, it will be extremely distressing. And it's not going to conclude before the end of this year. And of course, it's going to cause delay for the young children because it's inevitable. It's not a straightforward case. It is complex. There are previous proceedings which have to be considered, and all of that requires very robust case management in front of a different tribunal. And ultimately, the question is whether that is necessary or justified.
Sorry.
And ultimately, that is whether that exercise or that approach is necessary, proportional, or justified.
Yes. I think we would readily accept that the perception of fairness runs both ways.
Yes.
And that much as the Guardian might say that she feels poorly treated by not being heard, the other side of this is that if the appeal was allowed, then your client and the children's father have lost a judge who agreed with them.
Yes, and they would then
would have to try again.
Yes, and we cannot underestimate the impact that care proceedings have on parents, and certainly this parent who has now gone through a number of proceedings, final hearings for her older children and the younger two children, and how that impacts her, and actually having given evidence and then having been told that actually you have...
She's then faced with the prospect of giving evidence again.
Yes. And that has to be weighed up. Just the final point to do make is the evidence of the social worker was important, and it's unfortunate that we don't have that transcript.
Yes.
Because, of course, Ms May in her skeleton does set that out, and what the social worker's indications had been and what was suggested to her.
Yes, it suggested that the social worker's evidence was less than wholehearted.
Oh, yes, exactly.
Yes. Could you, just a matter of fact, is it the case that the eldest two of the 6 children have now been adopted?
No, the eldest two, or the 6 children. Sorry.
Yes.
Yes, I understand it.
Yes, because I know I saw that placement orders had been made, but nothing was said about adoption.
Yes, the eldest two of the 6 children were addressed. Have been adopted. Placement orders were made for both of them.
Adopted together?
No. Yes. Yeah. And of course, the child number 3 and 4 are in Ireland. Yes. Under special guardianship. Yes. And then.
That's been extremely helpful, Miss Meir. Thank you very much indeed.
I'm very grateful. Thank you.
And can we also express thanks to Miss May for her helpful skeleton argument?
Thank you.
Yes, Miss Sultan.
My lord, I'll try and be, noting the time, try and be as...
No, I haven't taken note of the time. You have as much time as you want.
I'm very grateful. My lord, if I may just quickly, picking up on the last exchanges with my learned friend for the mother, just make this observation at this stage. In my respectful submission, there is a real disadvantage if the matter is remitted to a new judge, for a number of the reasons that my lord has already canvassed with my learned friend. This particular judge, and I put it as highly as this, has been involved in these proceedings for a considerable period of time, but his involvement and interventions hitherto have not been the subject of any complaint by any of the parties. And in fact, if anything, there was a consensus, I would respectfully submit, that those interventions have permitted further thought to be given to some of the thinking around the best plans for the children when the matter started first of all.
So his previous indication was really very consequential.
It was very helpful,
Yes.
and it led to certainly some delays to a degree, but led to further inquiries being made, often at the instigation and suggestion of the Guardian, rightly so, to look at whether those particular proposals for those children were the right decisions. And in this particular case, even within the two younger children's timescales, as it were, the two older children, those decisions having been made, as has already been indicated, I think in December, by agreement. There was no suggestion that the learned judge hear from the Guardian in relation that the matter proceeded and concluded by way of agreement. And thereafter, my lord, in December, certainly, forgive me.
Different judge.
In relation to the two older children,
Yes.
thereafter, the issue of sibling contact has been very much in the mix so far as these proceedings have been concerned, because of the two children being placed in Ireland, coming for frequent contact, having frequent contact, sibling contact, and to a degree
Yes,
the contact
it's a
that's taken
case in
place
which
since.
there were important issues, not just about placement, but also about contact.
Indeed.
Because wherever the children were going to be placed, there were very important issues
Very
concerning
significant.
sibling contact in particular.
Forgive me for cutting across, very significant issues. So much so that when the matter in relation to Ralphie and Arabella was before the court again in February, it was necessary to have Dr. Call give evidence in relation to that particular issue expressly. And again, as a result of this learned judge hearing the positions of the parties and making that possible, it's unfortunate that we have a very limited note only in this appeal bundle of Dr. Call's evidence. The efforts have been made, as I understand it, by the local authority to obtain the transcript. Permission was given.
But could I say before I forget, it's quite likely that at some stage a transcript of the remarks on the Monday and the Tuesday will become available. The document that you have at the moment, which is marked as being provisional, is going to need at that stage to be set aside and corrected. And in particular, if during the period of time that we are considering our decision or reasons, the transcript becomes available, could you make sure that it comes to us immediately? Because the last thing that this situation needs is misquotation by amateurs.
Certainly, my lord.
And looking at the transcription process, it increases one's admiration for the art of the transcriber.
It most certainly does, my lord. My lord, I'll come back to the issue of the transcripts that we have in terms of the 6th and 7th of October, if I may. But if I could just finish the thinking, not only do we say that there is real and significant disadvantage in the matter being remitted to a different judge, but I'm not understanding that the Guardian's position goes as far as to say that she would feel in professional difficulties if she had to continue the matter still before His Honour Judge Oliver. She is a professional after all. I don't take the submissions that have been made on her behalf to go as far as that, should this court deem it appropriate for the matter to go back to Her Honour Judge Oliver.
Well,
I certainly say on behalf of...
I thought that, putting it a different way, that Ms Ferris had agreed to my suggestion that for the judge to, for the Guardian to go back in front of this judge in order to go into the witness box and give evidence would place her in an impossible position.
Well, I'm certainly glad for that clarification,
Well,
and I would expect nothing
but,
less.
I mean, that was that came from me, but was assented to. But I'm just wondering how you could see it in any other light. I mean, I can't think in 40 years of a situation in which you've gone into the witness box to bat for an argument which the judge has already said is hopeless.
Well, indeed, it may have been something, but as I noted during the course of the submission, that perhaps it was being suggested that it would be difficult for the Guardian to be placed in that position. But as I say, she's a professional. There's no question about that. Experienced Guardian, and as your Lordship, as my Lord has already indicated, that's a situation all of us find ourselves on many occasions, and that in itself perhaps is not a major obstacle to the matter going back to His Honour Judge Oliver in any event. My Lord, if I may, just very briefly, it's very unfortunate. I'm certainly grateful for all the efforts that have been made by the court staff, certainly, to obtain the transcripts that we received this morning. And inevitably, all of us perhaps have had to listen to them with very little notice, as it were, of
yes.
those. It is right.
Well, you were in a sense in the best position because it was part of what's nowadays referred to as your lived experience.
My Lord, certainly. And my learned friend's instructing solicitor, Miss Little, who
yes.
was present on both of those occasions. And indeed, so far as the transcript that we do have for the 7th of October, it is missing a number of passages, which is unfortunate, including the passage where the learned judge is going through specifically the welfare checklist. My Lord has already picked
yes,
that up.
I remember it well.
And there's another section.
That's largely reading out the terms of the checklist with one or two passing observations, isn't it? I don't think it's a checklist survey in the normal sense, but the judge was clearly aware of the terms of the checklist.
Well, my Lord, we would say he clearly had it in mind, and he was therefore indicating it to experienced advocates before him, so that to indicate precisely that he had it in mind. There is another passage.
In that passage, because I think this is only for concision that's been left out, because we've all heard it. So the judge goes through that passage, and then he says, I can't do it. I can't make an adoption order. So he's actually thought about the factors and then says, I can't do it. But what's your submission on that?
My Lord, my submission on that, and that's why I say it's unfortunate that the events of the 6th of October are not contained in the transcript. If very briefly, I can say this. I'm not able to say precisely the time that we went into court, and I don't necessarily dispute that we perhaps went in around 10:30. And on the 6th of October, we heard the evidence having heard the evidence of the social worker. On the 6th of October, the learned judge, having flagged up that he wished to make certain observations, and he made a number of observations in similar terms to that which we had on the 7th of October, but expressly, and one of the passages, one of the particular notes that I made, that he indicated in a number of different ways, but quite expressly, that notwithstanding what he had said, he was very happy to continue with the hearing and continue to hear evidence if any party wished him to do so.
Just a moment.
I don't have the precise wordings of some of the other expressions, but in similar terms, that notwithstanding what he'd said, the indications that he was giving as to his thinking, having heard, particularly I would respectfully submit from the social worker, that this was his thinking, and suggested that we reflect upon it overnight, and that was effectively what we did. There was ample opportunity, in my respectful submission, for the parties to express our own views, both within any further discussions that we were to have as advocates, but also to the learned judge. What we see in the transcript in terms of how he expresses himself the next day, in my respectful submission, was not that much different than before. He was simply reiterating again what he had said yesterday. And again, the issue, the remedy, in my respectful submission, as to any dissatisfaction that any party might have had with the learned judge's expressions, both on the 6th of October and anything that he said on the 7th of October, was in their own hands. And there was ample opportunity during the course of that day, during the course of that reiteration of his observations from the day before. At one point, my recollection is that we had a further period, and I think it followed after the passage that we can see in the transcript towards the end when the Guardian's representative says what she says, that we then had a further period upon which we were encouraged to reflect, and we did have that further discussion of reflecting. And again, we say that the remedy was in the local authority's hands or the Guardian's hands to go back to the learned judge to say that they did wish the hearing to continue, they did wish the court to hear from the Guardian in particular, and expressly to have amplified or even to have given a clue as to what it was that this much further evidence that the Guardian would have wished to have told the judge, what that further evidence was, even if it was in headings or in brief. So some indication of the areas of evidence that the Guardian felt that she would be in a position to give that might perhaps have had an impact on the learned judge's indications.
So citing this within the record that we have, if you have the first page of the informal transcript.
I've got the first page of the transcript, my lord, yes.
Yes. The way it works with your submission is that the judge says, how are we going to proceed after I dropped the bombshell yesterday? Carrying on as if nothing's happened, question mark. At that point, what do you say? You say that Mr. Coates should have just said, yes, I'm going to call the family finder.
Well, my lord, no, because the learned judge had said the day before, I'm perfectly happy. I'm perfectly happy.
Yes, I know, exactly. So what you're pointing out when you say the remedy was in the hands of the appellants.
Well, it would not have been as if nothing had happened, my lord. The fact that the learned judge had described what he had said in the way that he said was the terminology that he used, but he wasn't saying that he was not willing to hear that.
Yes, but I wanted to understand what your counterfactual is, which you say the local authority and the Guardian should have adopted. And the way I'm understanding it is that in response to the judge's opening remarks, Mr. Coates has said, yes, well, thank you for your indication, but I'm now going to call the family finder. Is that what you're proposing?
My lord, no, I'm not. I'm simply saying, my lord.
But what are you proposing?
Forgive me. What I'm saying, my lord, is that it was open to the local authority to say, respectfully, we feel, either on behalf of the Guardian or the local authority, that there is much more that should be considered by the learned judge, which the learned judge hasn't heard, i.e. the further evidence of the Guardian.
They ought to have engaged in submissions to try and make him change his mind.
Well, at least have flagged it up, because there was he had the detailed position statement, he had the previous report of the Guardian, he had heard from the social worker, and given the views that he had given in relation to, he had asked expressly, has the Guardian changed her mind? And had been told that she had not, but that she had, I think the expression that was used, she had much she would wish to say. I'm just trying to, yes, that she would have, there was much that she would have wished to say, which she would have wished the learned judge to have heard. It did not say at that stage, or at any time, well, there's no point in my hearing from the Guardian. There's no point in my hearing from the family finder. There was no substantive issues between the parties as to the family finder's evidence being of limited value. There was no particular criticism, as far as I recall, being expressed either inside or outside court as to not hearing from the family finder as such.
So, just so I've got this fairly, is it or isn't it, should have made submissions to change the judge's mind, should have set out their stall for all the things that the witnesses would tell him?
Not all, my lord, just at least give an indication. Because what is being expressed, I've said that in my skeleton argument, that the Guardian has a lot to say. There's a lot of evidence she wished to give. Now, at the very least, something, either reduced in writing or flagged up in oral submissions, they did not need to be extensive.
Right, so it was open to them to explain what the lot to say was.
Well, indeed, such that it might have persuaded, because all the judges, however the judge had
persuaded the judge what? To do what?
To consider whether that further evidence factored into his thinking such that he might have been willing to look at the matter in a different way.
It seems to me, to be honest, Mr. Sultan, to be quite an extraordinary submission that after that the judge has given, whether it's a strong indication or a preliminary determination or a final determination, that it's incumbent upon a litigant, whoever they are, to engage in argument with the judge as to why they are wrong in the indication that they've given. I mean, isn't the process that you get on with it in one way? I mean, either you call the evidence or you say, I can't do this.
Well, my lord, yes. We've all
but
been
I
in
don't.
that
I mean, you seem to be suggesting a middle road of wrangling with the court, which seems to me to be totally inappropriate.
Respectfully,
at the
my lord,
moment.
I'm not suggesting a wrangling with the learned judge. The way that I would wish to express it is that there was an opportunity, given all of the factors that were in play, there was an opportunity, and many of us have been in that position on other occasions, where we try again to see whether we might. The way the judge has expressed himself on the 6th of October was, I cannot see, or I'm not sure, or the way in which he expressed it on the day before, left it open for him to be able to say, I'm happy to continue with the hearing if any party wishes me to do so. Those were the express words used. So in my respectful submission, that was an opportunity to have at the very least flagged up or invited the judge to hear submissions, if not the evidence, so that the judge had some idea, some inkling as to the further evidence that the Guardian was submitting and would continue to submit.
The normal course of events is you don't have to persuade judges to let you get into the witness box if you're the guardian for 4 children.
There was no persuasion required, my lord. She could simply have said, I do wish to give evidence and I'm going to the witness box.
Right. If we look at the first page, which you'll still have there, that no more than half a minute had passed before the judge says in the middle of the page that he's giving a clear indication he cannot at the moment accept the care plan, and that he's told the parties at this stage because he didn't want to waste time hearing evidence which could not in any shape or form change his view.
My lord, I understand that.
I mean, it doesn't that create difficulties for somebody, however robust an advocate, to say, well, that's unfortunate, but I now call the Guardian?
My lord, there are a number of factors to be looked at that particular point, not least of all the issue of delay, not least of all whether or not, in fact, I'm just looking at the one particular passage. Sorry, just one moment, my lord. The further time, as I recollect, that was being given was to include consideration of whether any party was going to be inviting him to continue with the hearing or hear particular areas of evidence. And in the circumstances, I would respectfully submit that I'm repeating myself. There's no perhaps merit in continuing to repeat myself to that effect. It would perhaps be more helpful if we did have the transcript of the 6th of October hearing, because the reason that I say that, to look at the whole issue together, the learned judge makes it quite clear that he hasn't made a preliminary determination. That much is clear in the exchanges that we have here. And the impression, the unfortunate impression perhaps, that emerges from the way in which matters developed, when he asked in terms, not only has the Guardian changed her mind, but that he was in effect inviting the local authority to reconsider their care plan, and the local authority had declined in effect to reconsider that care plan in light of those indications, and that therefore in those circumstances it was a judgment call, as it often is in these situations, by all the parties and their advocates, notwithstanding what a judge might say. I don't say it's wrangling, my lord, but it's an attempt to see whether anything can be moved, whether the dial could be moved by hearing further from, in particular, what was being submitted, the Guardian. Local authority also at one point were of the view that the hearing should continue, is my recollection. Ultimately, that decision not to give evidence was the Guardian's, and not to proceed with the hearing as it was the local authorities not to reconsider the care plan, the local authorities, and the court found itself then in the position that it did with the permission to appeal note that came through later on that same morning. And in those circumstances, I say that the learned judge, there was no question of recusal, no suggestion being made. One of the passages that's missing from the 7th of October is a passage, an exchange between myself, not so much an exchange, a submission made by myself to the learned judge, precisely on that point, that as I understand it, I've heard it again for the first time in the audio recording, that as far as I'm aware, and I was not contradicted, as far as I'm aware, no party is suggesting that it should not proceed before Your Honour, or that Your Honour should not deal with this matter. So the issue of recusal, in effect, I don't use the word recusal, but it is flagged up that no party was suggesting that he should not continue to be the tribunal.
But isn't that just the other side of the coin of what was achieved, which was
and didn't they then they applied for permission to appeal?
Yes.
And so in a sense, a fork in the road was reached, wasn't it? Where they said, right, we want to appeal, and then the case had to be stayed because it couldn't then carry on. But that, as my lord says, that's the flip side of saying it can't carry on in front of you, isn't it?
Well, that's what flows, but in terms, that's not how it was presented. It was not put to the learned judge that the matter should be before a different judge. Certainly that's one alternative that flows from appealing. That might be what happened, but it was not expressed in that way, that it should not be before him or that he should recuse himself because of the strength of his expression of or the views that he had wished to share with the advocates, having heard particularly the evidence from the social worker. And so that was again a remedy potentially, my lord, either to seek clarification or to have said it in terms, because that, in my respect, was a further remedy on that occasion, which was not taken up. Well, so far as my, if I can just go to that for the moment, in terms of my skeleton argument, I adopt and endorse all that's been said in the skeleton argument on behalf of Mother and my learned friend from Mother who attends today, and share the court's regret that my learned friend who attended on those 2 dates and throughout the earlier hearings could not attend today. But so far as the arguments are concerned, we appear to be essentially as one in relation to the both how matters progressed and expressly in terms of the remedy that was available at the time to the local authority. My reading, my lord, of the authorities that very helpfully our attention has been drawn to, if I can just summarise it in a few brief sentences, the authorities would appear to suggest that the bar is set very high in order to demonstrate conduct by a judge that amounts in effect to bias, effectively, or a concluded determination. And that is not, in my respectful submission, the circumstances that we were dealing with here. But even if the court finds that that was the case, it still does not flow from that, my lord, that the matter should not remain with that particular judge, and it should be remitted to a different judge in terms of being able to progress the matter before the same tribunal. And a number of those authorities, that has been the decision, from what I can see. In particular, if I could just go to I think there are a number that make the point, because part of the exercise that this court perhaps has to engage with is what was the unfairness in terms of the decision, effectively, as the applicant, appellant, and the other respondent, the guardian, seeks to suggest. What was the
well, I think it can be put in different ways, but
what was the unfairness, effectively?
The test that we have to apply in this context is really whether the decision, such as it was unjust. And the argument that you're having to meet is that it was unjust to parties, as it happens in this case. The local authority and the guardian are not parents as it might have been, to eliminate their considered proposal for this little girl without hearing the guardian's evidence or any submissions. And I think it comes in that way as I see it, namely that's not doing justice.
Well, the learned judge had the guardian's reports, had the guardian's written evidence, had the guardian's detailed position statement, and in those circumstances, what this court perhaps will need to use another clumsy word, grapple with, perhaps, my lord, is where was the unfairness in terms of what would be missing from the oral evidence, if that is the exercise that this court is engaged with? Where is the unfairness? Does it flow simply from?
I don't know where to start, but I mean, an explanation of why the guardian, if she did, disagreed with the observations that the judge had made.
Which she had expressed. She had expressed her support for the plan of adoption. Her position remains the same.
But I mean, surely, at least on the principle of hear the other side,
yes,
that if as a judge you state 6 things about what's wrong with adoption.
Yes.
I mean, isn't it elementary that the most powerful witness in favour of adoption should be heard before you knock it out?
Well, certainly that would have been one approach, but having heard from the social worker in particular, and having already been cognizant of the guardian's continued support for the plan of adoption, notwithstanding all of the reservations perhaps that had arisen and the concerns that the judge expressed about effectively the cogency and the cogency of the proposals around contact in particular, how realistic those were, and the views of the social worker, which appeared to be, if anything, half-hearted in support of the plan herself. He was entitled to take all of that into account, because the question put to Guardian, all of the parties having heard that evidence, is the Guardian's position still the same? So in those circumstances, my lord, it's difficult to know what more he could have heard from the Guardian, is how I would put it, perhaps a better. An experienced judge, knowing all that was in the mix, what more? Him asking that particular question would have been for a reason, I would suggest. And he asked that question. The answer came back. The position remained in support of adoption, despite not just what the social worker had said, but the exchanges during the course of that social work evidence by the judge, trying to understand what is it you're saying would be the level of post-adoption sibling contact, how is it going to work, and so on and so forth. And despite all of that, the answer in response to whether the Guardian's position remained the same was that it did. So it's difficult, in my respectful submission, to understand what it is that the judge was likely to have heard. Yes, of course, it perhaps may have been a concession that perhaps can be made if he had chosen perhaps to express himself with the caveats that some of the authorities say that it may be a better course of action to do it in this way, perhaps. But nobody could have been perhaps in any doubt as to what he was saying, as is clear in this transcript. I have not made a preliminary determination. I am giving my indications. And he said on more than one occasion why he was giving those indications. And yes, he expressed himself in powerful terms, but that's not unusual. The authorities that the court has invited us to consider. Equally, there have been occasions when tribunals have expressed themselves in very trenchant terms, in very powerful terms. What is the impact of the fairness, what is the impact of those trenchant or powerful observations upon the fairness of the process? And we say, my lord, that there hasn't been a disruption to the fairness of that trial process, as appears to have been pleaded certainly in the local authorities' skeleton argument. My lord, I don't know, I didn't think there was any other particular, but I can just quickly look at that just in case I have missed something. I don't believe I have. Certainly much of it has been dealt with in the written skeletons, both of mine and my own friend for the mother. I don't know if I can assist, my lord, in any particular.
No, that's been very strongly argued. Thank you very much indeed.
I'm very grateful.
Before I forget, Mr. Bain, I wondered why, when the judge's order was made on the 7th of October, it took, I think, 20 days to file the appellant's notice?
My Lord, could I turn with that?
Yes.
Because that hadn't... I'm afraid it was internal delay within the local authority putting together the right paperwork, my Lord. So I extend an apology for that, because of course clearly the matters were urgent, and this needed to be brought to the attention, of course, of this.
Well, I can sort of understand that it might be a case takes its place in the queue where you're seeking permission to appeal. But in case where you've been granted permission to appeal, the only thing you've got to do is file an appellant's notice.
I completely understood. And I'm sorry that that wasn't done in a timely way.
Right. Now, is there any reply?
My Lord, can I just perhaps make this final submission? There's obviously been exchanges about what the local authority, the Guardian, could have done at the time of the exchanges before the judge. One only needs to then...
So this is Miss Sultan's counterfactual.
Yes, but one only needs then to almost fast forward through the process that had evidence then been heard, for instance, from the Guardian. The judge then makes a decision that almost certainly determines that adoption is not in the best interests of that child, and so that, of course, care plan is effectively refused, perhaps long-term foster care even potentially returned to the mother, but other options then are determined through that decision-making. It is likely then that either the local authority, the Guardian, or both would have sought permission to appeal on the basis of a
if the judge had given an acceptable indication, and as Miss Sultan said that he did, why didn't Mr. Coots just march the family finder into her evidence, and in due course the Guardian be called by Miss Little, just to, as it were, ignore and persuade, I think, is the strategy that is being suggested.
Back to the submission I made much earlier this morning, my Lord, one couldn't unsay what had already been said, and the local authority understanding and reading of that exchange or set of exchanges is clear.
Your counterfactual answer is to say, assume exactly what was said,
yes,
and then at the end of all of that, you put your witness into the box and you say to the judge, well, we're going to carry on anyway. That's the counterfactual you're talking about.
And then you follow that through, my Lord.
To the end.
To the end, given all that...
Everything he said on the 7th.
Yes.
Yeah.
But I think the way by the time we get to the end, then I understand what your submission is about that.
Yes.
When one looks at the transcript, it's really that it seems that at a very early stage the judge is strengthening his position.
Yes.
And so, whereas Mr. Coots appears to have been trying to de-escalate the situation prior to calling his evidence,
yes,
your case, not saying it's right or wrong, is that the judge instead escalated the situation by making his position as strongly clear as it was.
Exactly, my Lord. And in fact, I haven't, in the course of my submissions, identified right through to the end of the written document that we do have, that you follow through right to the end of that document, and the exchanges continue to highlight that when the judge is saying, for instance, this is the internal page 5 of 6, so my indication was not necessarily thinking about a return to the mother. That wasn't that part of the exercise. I hadn't gone through that. That is, in my submission, highlighting he's already gone through, in effect, his own sort of welfare exercise, in part, to rule out adoption.
Right, so not very keen on this terminology, but it's linear.
I'm afraid that's the submission I made, and yes. Now, my Lord, that's nothing more that I need to add. Thank you.
we'll just rise for a moment and consider where we've got to. Would you stay either within the courtroom or just outside?
Of course, Ma'am.
Thank you.
Sorry, my screen was. I got the Guardian's team up last time. So.
Excuse me. I just like to let you guys know it is still being live streamed.
Yes. Thank you. Thank you. Yes, sorry. Thank you. No, of course not. But no, but you know, it's primarily just
Thank you, Charles.
Learn a lot from you. I think I'll send her to watch some of your cases.
Rise if I will.
Yes, do take a seat. One day, thank you. Can we thank you all for the efforts that have been made to bring this matter on at really quite short notice. We've considered the submissions that we've heard, and we're in a position to tell you what our decision is, but we're not going to give our reasons today. Our decision will be as follows. Firstly, we grant permission to appeal to the children's guardian. Secondly, we allow the appeals of the local authority and the children's guardian. Thirdly, we remit the local authorities applications, or application, which I take to be the only applications in the underlying proceedings, to the Central Family Court for urgent determination by another judge who is to be nominated by the designated family judge in consultation with the family presiding judge for London. In brackets, I explain what is probably obvious to you, that is to allow for the greatest possible flexibility in finding a judge who is able to deal with this long delayed matter as soon as possible. Fourthly, we will direct that there is to be an urgent case management conference before a judge nominated by the designated family judge. Again, in parenthesis, that can either be the designated family judge herself or some other judge nominated by her, whether or not that is the judge who will be nominated to conduct the trial. Fifthly, we will direct that the recordings which have been shared with the parties for the purpose of this appeal are to be deleted by them following the handing down of our judgments. You'll appreciate that's simply to make sure that confidentiality of the parties is maintained. And finally, we will make any other suitable orders that may be suggested to us by the parties by communication, ideally a single communication on behalf of all by 4 o'clock tomorrow afternoon. Again, in parenthesis, we are not intending to trespass on the case management of this matter. We simply don't have the knowledge of the underlying issues. But if there are any other useful directions that you think are necessary as part of our discrete task, then please suggest them. So those are the orders which we will make. Could, Mr. Bain, you kindly draw them up in consultation with your colleagues and send them in by the end of the week?
Of course.
Ideally today,
yes.
But as soon as you're conveniently able to do so. And the orders will then be made.
Yes.
As of the date when we can get to make them.
Of course.
If there are, what I hope will be only a matter of some few days before you receive the reasons for our decision, it's nevertheless, I think, a case in which the sooner that the wheels of justice are restarted,
yes.
The better.
Thank you.
Are there any other matters?
No,
that,
just to extend.
Excuse me. Yes. I'll come back to that, thank you. Yes.
Just to extend, as I made clear at the outset of today, the gratitude of all. We would not have been affected today.
It's been as good a process as it could have been. Thank you. Now, I'm required, and do tell you this, as you will be aware, when you receive our judgments, they'll be in draft for you to help us with corrections, editorial mistakes and so forth, and while you have them and before the hand down, those will be embargoed to just yourselves, the legal teams and clients. There's a warning at the top of the order. The consequences of the breach of that, please observe it.
My Lord, yes. My Lord, I think what I'd understood, obviously at a point where the full transcribed documentation from the recordings becomes available, either we, the local authority, or the parties can inform this court, or this court might get
yes,
them.
well, there'll come a point which will, I think, arrive when we've both made our order and handed down our judgments, formally speaking, when our role in this comes to an end.
Exactly.
And so if it hasn't arrived by then it's not our concern. I can tell you that we did consider whether the informal transcript that we have of only one of the 2 days, with the prospect of the formal transcript sometime arriving, some unpredictable time, might come in during the time when our reasons were to be reserved. Our conclusion about that is that there is nothing that could be contained in those transcripts which would make any difference to the order that we could make. Otherwise, we would have postponed informing the parties of our decision. But our concern for the urgency of this matter is such that we were not prepared to wait for even another week before getting on with this.
Understood.
So please, in relation to the transcript, particularly of the remarks, and if they come in, the remarks of the previous day, share them with us if they come in before judgment is handed down.
Of course.
But that may lead to, obviously, amendment to the record that we have been able to create so far.
Thank you.
Thank you for thinking of that.
Good afternoon.